everybody, welcome to John's Briefs back again with our legal expert, attorney extraordinaire, judge pro tem, Arizona Ranger, firearms instructor. Is there anything you don't do?
Faithful husband and father.
There you go.
By the way, I don't know if you guys know, but John's Briefs, if you could see below the table, I'm telling you, they're pretty good.
Many people have asked, are you wearing pants? I'll never tell. But we want to talk today about the defensive display of a firearm. We finally saw somebody in Houston as a victim of an armed robbery who had their gun on them.
Yep.
I was so grateful for that. Houstoners, get your acts together. And I want to talk about the legalities of a defensive display and how these can be a gray area.
They sure are.
Firearms Legal Protection is who I trust to help me after a use of force incident. If you're a Firearms Legal Protection member, you can attend our monthly active self-protection training seminars for free. Check out all they offer to their members at the link below. So I think this is interesting. I mean, I think in her case, if you go watch the video, it's linked in the description, she could have shot that guy.
Yeah.
And she probably should have.
And that's where, when we have defensive display cases, by the way, the statute we're talking about for Arizona is ARS Chapter 13, 421. So that's the actual statute. And it's a new statute. We've only had that in Arizona, I think, a dozen years or so, relatively new.
And as far as, am I right on this, Tim? So we've seen a couple of actual court cases, but nothing at the appellate level.
Correct. To my knowledge, no appellate review yet.
Yeah.
So we don't have any, case law per se. Yeah. So
remember, trials don't create case law.
Right.
Only appeals create case law.
And some appeals are even sealed, so that they don't count either. But where you're in the face of what we see in this video, where the guy's clearly armed, he's got a rifle, he's clearly attacking. Defensive display is probably not going to come into play legally. This is going to be, self-defense, ag assault, et cetera, et cetera, et cetera. So, but the theory behind defensive display is that if you're reasonably in fear of physical or lethal harm. So it doesn't have to be I'm in fear for my life. It could be I'm in fear for getting the snot kicked out of me.
Now, of course, we're talking here in Arizona.
In Arizona. It's Arizona only. A lot of states have similar statutes, but
make sure you ask an attorney in your town,
absolutely,
in your jurisdiction, bar admitted in your state, because there are some states that if you produce a gun at all, then you're going to get charged with brandishing or ag assault or reckless display or something like that.
We don't have brandishing here, and a lot of people say, well, we don't. What's ag assault? We have battery. Probably the same thing. I know Florida has battery. We have assault. But basically, it's the inappropriate touching of another human body. Obviously, a bullet would be a way of doing that would be incredibly injurious. But in Arizona, if I ask your girlfriend to dance, not knowing it was your girlfriend, and you get up and you're coming towards me, and I can just see in your eyes, I'm about to get my butt whipped by a guy that's way bigger. I can't tell you about martial arts training. I would never want to get mad at you. But the point being is that I'm about to get my butt whipped, and I'm too old and fat to get my butt whipped. So in theory, in Arizona, I can show you that I have a gun. I can tell you that I have a gun. I can put my hand on my gun and say, hey, back off, man. I've got a gun. Don't make me use it. And that's legal. That would usually be aggravated assault. But this statute makes it legal. The problem is,
if you are in imminent fear of ordinary assault or
physical harm or deadly harm.
Or deadly harm.
Now, the problem is that I think a lot of mall ninjas go out and they read this statute and they decide they're going to go out there and now they're going to use it as a sword instead of a shield.
Yeah.
And I've had a couple of those yahoos that wind up getting in big trouble. So you basically go out there and now you're bulletproof and invisible, and you can bump into people as you walk through the bar, and if they say anything, you go, hey, back off, man, I've got a gun. Well, what ends up happening there is 3 people have you on video being an idiot. Exactly. Yeah. Anymore. 3 people have you on video being an idiot, and 2 of them are already on the phone with 911.
Right.
And you go back to the bar to buy all your buddies a beer and talk about what a big man you are, as suddenly you're spread eagled and arrested for aggravated assault.
Yeah.
So it does exist, and I think it's a good law, but I also think that it's often used, as I said, as a sword instead of a shield, and it causes a lot of problems. It's
so you said something to me that the client that you had that had no idea about that, that law used it successfully. All the clients who knew about it abused it.
I've actually tracked it because it came into effect when I was, I've been a teacher for a firearms instructor now for going on 30 years. So it's one of the few laws that has come into effect while I was doing that. So I was very interested in it. So I tracked it, and I believe I had 9 clients where it's come up. And on 8 of those, the client used it as a sword because they thought it was cool and they'd memorized it and they knew the statutory citation to yell at the police officers, that kind of guy. You know the guy I'm talking about. Yeah. And the one client of mine that had never ever heard of it, I brought it up with the prosecutor and got the charges dropped. Okay. So yeah, it can be used very well as a shield. I'm not a big fan as a sword, obviously. Yeah.
So in a state where, if you're actually facing a deadly threat, like somebody is you are at imminent fear of death or great bodily harm, I don't recommend a defensive display generally. Generally you use it.
I mean, it's kind of like, I always tell people, it's kind of like birth control. It's not a part-time thing. It's an all or nothing thing. So yeah, if you're in fear, I've had I think 2 or 3 cases where perversely I had a conversation with my client. If you had shot the person, we'd be in better shape legally.
Yeah.
You're in fear for your life, then why didn't you shoot them? You drew a gun and brandished the gun and scared people, but you didn't shoot. So I guess you weren't in fear for your life, or you'd have shot. So perversely, had they shot, it would have been easier to prove that they were in fear for their life. So it doesn't make sense, but that's how it comes out sometimes.
Yeah, and I can also see some cases, some incidents, some circumstances where you might want to draw a firearm and not shoot.
Sure.
You know, you might want to draw and point at somebody.
Somebody
draw
with a baseball
challenge.
bat 15 yards away says they're going to kill you. You go to a low ready and you tell them to drop the bat.
Exactly. You know, I draw that gun, or he's got a knife, but he's 15 or 20 feet away from me, and now I know I can get up on him in a half second, and I go, hey, back up, drop the knife, leave me alone. And he does, and he, you know, hex off, and so good. That's a good.
And you know what the
defensive display.
distinguishing factor there is oftentimes between it working out well and not working out well? Do you call the police? Because a lot of people go, oh, thank God, I dodged that. And they sit down on the curb and they get their blood pressure back under control, get their heart rate good, and then they drive on home or they go to dinner. And when they get home, there's squad cars waiting for them.
Right.
He who calls first is the victim. So
I can tell you
the cops.
Definitively, if you have to use force, you need
Or
to
the
call
threat
the cops.
or the threat of force.
Or the threat of
Yeah,
force. You need to call the cops.
Amen.
And my suggestion is be first.
Yep.
Because when you're not first, I can tell you, I can't talk about it yet, but I'm working a case right now that this is a major issue, and it will jam you up. I'm telling you. So there are times where you can, you know. Again, I can see a case of, we see these armed robberies sometimes where a guy will come and he'll brandish a gun and then put the gun away and he's collecting and doing his things. Now, he's still a deadly threat. He's threatening you with that gun even though it's put away, but you might feel like, hey, I might be able to challenge this guy and get him to run off without actually having to shoot him. I'm not saying you have to do that, right? You probably can still shoot that guy because he's a deadly threat without legal repercussion, but you might choose morally, well, I have an opportunity here. So once I got the gun on him, I know I've got him. I've got the drop. So hey, man, you know, get away from me, and maybe that's okay, right?
Yeah.
That'll be all right. But that's a pretty thin slice of the pie.
Right.
As a general rule, I see a lot of people get in trouble when they think they can display a firearm when in reality they're committing aggravated assault.
Correct. Happens. I mean, they're paying for my house.
Yes.
Yeah. These people that.
Yeah, we've told this story
Yeah.
before,
Yeah.
you know, of the guy at the seminar that I did for firearms legal protection, who then was like, you know, well, this guy, you know, we were arguing about stuff, and he got out of his car, so I took my pistol and I set it down on the dashboard, and then he went away, and I was like, sir, you just admitted aggravated assault here in public. And, you know, again, there was even a couple of cops in the room, and they just chuckled about it, whatever.
Right.
I'm not going to jam the guy up on it. It's long ago.
Yeah.
It's fine, whatever. Get out of here, dude. But you don't want to do that.
No.
You know, that's...
The guy dodged a bullet, probably twice.
You're right.
That same day, yeah.
Well, and again, when you see somebody that gets hemmed up on these defensive displays, what's that end up costing them?
Oh, what? Well, it depends. I mean, if you take it all the way through trial, it's insurmountably high. But
I mean, the average, you said you've seen it 9 times?
Yeah, I average on those probably 30 grand. So yeah.
Wait. I'm sorry. Would you say that again?
$30,000.
$30,000.
Yeah, because you forget that. Obviously, you're not just going to take the plea of ag assault. Well, okay, you get your toothbrush.
Guilty,
you're going to prison for 5 years. No. So that means
you've got a gated community.
So you've got to do background check on the victim. You've got to do polygraph of your client. You've got to do several meetings with the prosecutor. You might have to go out on the site and take measurements and photographs, get a private investigator. All this stuff leading up to settlement conferences, plea agreements, et cetera, et cetera, et cetera. So pre-trial, you know, that 3 to 6 months pre-trial, that's going to cost you around $30,000 in the Phoenix metro area. How much is it going to cost you in San Francisco or New York or Chicago? Twice that. So yeah, it's a lot of dough. Don't do stupid stuff. So you're paying other people's college tuitions if you do.
My big thing, I'm not trying to convince you not to carry a firearm.
No.
I carry one every day.
I do
so
too.
do you.
And I think that anybody who's reasonably trained and responsible should.
Right.
Yeah.
But I want you to understand that when we make mistakes, misconduct involving firearms is very serious.
There's zero tolerance. I always tell people if you swing a garden rake at somebody, it's probably a misdemeanor. If you point a gun at somebody, I guarantee you it's a felony.
Guarantee you
zero
it's
tolerance.
a felony.
Exactly right.
And many prosecutors will not budge on those and will not talk about them. And you're going to get felonies, and you're going to go all the way through trial. And now it's not going to be 30 grand; it's going to be 130.
In Arizona and many other states, there's literally a different category of charging and sentencing if a firearm is used. I mean, it's just it's any other weapon you use is different than a firearm. So, extra responsibility.
So, also in some states, the mere presentation of a firearm is considered deadly force.
As in Arizona, I
Yeah,
believe.
Arizona is as
Yeah.
well. Because again, you brandish a firearm at somebody. We don't have a brandishing charge. It's aggravated assault.
Yeah.
And that is a felony charge.
Right.
I know Michigan has a case law there that in their state, pointing a firearm is ordinary force, not deadly. But that's an oddity. That's
Wow.
a kind of a unique kind of thing.
Because if you point a gun at me, I'm in fear for my life.
Absolutely.
And I'm going to use lethal force to stop you. So that seems to be a contradictory statute. Yeah.
Interesting
Weird.
there.
Contradictory statutes.
Yeah, weird, right? So anyway, I want you to know there are times that you can, and maybe even should, display a firearm as a deterrent.
Correct.
Just make sure you're always using your firearm as a shield, not a sword.
I guess perfectly said. I would also add just simply this: that but before you decide to use your firearm as a deterrent, you better be able to prove that you're in fear for your life. Because if you're in fear for becoming in fear for your life, you're going to prison.
Yeah.
So-
And Arizona has this interesting bit of the defensive display at ordinary force. The other part of that is, remember, if it's ordinary force, a guy says, "Oh yeah, I ought to beat your ass." And you go, "No, I have a gun, get away from me."
right.
Okay, you probably get away with that from a statutory perspective, but you're bluffing
You're absolutely bluffing. Yeah.
because you go, "Well, wait a minute, but I can't use it."
And you're bluffing with deadly force. We also, in Arizona, have a statute that you can't use lethal force to stop a property-only crime. Absolutely not. Not ever, ever. But you can threaten to. So the shop owner and the kids come running in, they steal a case of beer and they're running out. I can chase them out in the parking lot. I know I can't shoot them.
Right.
But I can rack my shotgun and threaten to shoot them to make them stop. That's legal. It's also the most stupid thing I've ever heard in my
very
entire
stupid.
life, but it's legal. So.
And I know somebody's going to say in the comments, "Well, wait a minute, John, if I display a firearm at him and he keeps coming at me like he's going to do that, well, now I'm afraid he is going to kill me because he's going to take my gun and kill me." Okay, but remember, you're paying this guy
You're buying it.
$500 an hour to make that argument to the prosecutor, and you're going to pay me to write the report that says this is reasonable.
It always boils down to just because you can do something doesn't mean you should do something. If you have the ability to not go down this rabbit hole, for God's sakes, why would you?
Especially given the fact that there's a $13 solution to this.
Watch where you're pointing that lipstick, pal.
You know, so I always tell folks, listen, something between a harsh word and a gun can keep me from spending tens of thousands of dollars
That's correct.
defending my decision making
That's right.
in court. So she got away with it, and she was totally justified
Right.
in what she did.
In this case, it was so clear that she was in fear for life. that,
Super
yeah,
clear.
it's not really going to come up.
And I think, you know, she clearly could have shot him, and I think probably should have
Right.
shot him. That
I
would have
guess-
ended the threat soon.
I guess my biggest observation would be if you're ever going to rob like a liquor store, you know, up close, make sure you have a really cheap Tosco 3 to 15 scope on your AR-15.
Yeah, oh, yeah.
Because that's, you know, that way if the person gets really far away, you know.
Yeah, you can do those things. Anyways, so be careful with that. Tim, man, I appreciate the discussion.
Always, this is so fun. Thanks.